Well, it's time for this week's Legal Lowdown with Atwood Marshall Lawyers. Each week we ask you for your questions and some advice. Sometimes we run out of time to answer them all. So today we're going to respond to a few that have come to us over the past couple of weeks, focusing on the family law space. To help us, we're joined by family law special counsel Hayley Condon from Atwood Marshall Lawyers. Welcome to the program again, Hayley.
Good afternoon to you, Carla, and to your listeners.
And the reason why we can't get through to them all is some people find it hard, a bit reticent to share their stories and their questions and concerns, because family law, it really is an emotional area of the law.
It is a very emotional area, Carla, and it's an area of the law which is very specific to different types of relationships and obviously different family circumstances.
And it's one of those things where you would have seen plenty of disputes over the years, and it's hard to take when you're in it as a family member, not you. It's hard to take the emotion out of it.
It's very difficult, Carla, because at the end of the day, this is your life, and what you're discussing ultimately is your future, and what resolution you reach with your former partner is going to have a significant impact on how you move forward in life.
All right, well, let's get straight to it because there's actually quite a bit to get through, Hayley. This one came to us via text from Carol in Algeciras. She says, I'm in my 50s. I've recently separated after 24 years of marriage. My husband managed all our finances. I know nothing about our current financials. I'm worried I'm going to be at a disadvantage. Where do I stand and what are my rights?
Carla, this is not an uncommon situation, unfortunately, where parties in a relationship choose to adopt different roles, such as one party managing the family finances and the other party assuming the role of primary carer and homemaker. And look, this may work very well for the family unit until a separation occurs. If the separation is acrimonious, the party who has been managing the finances may choose to be unnecessarily difficult during the settlement process in terms of sharing information and documents about income and the property pool, leaving the other party potentially at a disadvantage, having to try and play catch up during the property settlement process, and at times with questions as to whether their former partner is being truthful and disclosing everything. So when it comes to property settlements under the Family Law Act and the applicable court rules, it is very clear about the issue of disclosure. Each party has an obligation to give full and frank disclosure of all information and documentation that is within their possession, power and control, which is relevant to their income, assets, liabilities and financial resources, whether held by them personally, jointly with another person, or via an entity such as a company or a trust structure controlled by them. The court rules set out the nature of the documents to be disclosed, and this obligation forms part of both the pre-action procedures, which are to be followed prior to commencing court proceedings. So if parties are negotiating with each other and trying to resolve matters outside the courtroom, and during any court proceedings. Now, while there is a clear obligation for disclosure imposed on both parties, the question is, does each party always comply with their obligation? Now, if court proceedings are on foot and a party is being difficult or refusing to comply with their disclosure obligations, then orders can be made for specific disclosure. Subpoena can be issued for third parties to produce information and documents. And there is now the ability for a party to actually apply to the court to request the release of superannuation information for their former partner held by the ATO. In addition to that, searches can be undertaken, such as through land title registries and ASIC registers. However, this all comes at a cost. So really, the best approach is not to leave the family finances solely to your partner. Even if they insist on managing the finances or you prefer not to handle things like that, just keep yourself aware and involved as much as possible.
It's hard because, like you said, Hayley, at the start, sometimes in relationships and with the best of intentions, you think you're going to be married once and forever, right? And with the best of intentions, you take on certain roles. I know that in a friend's case, and then my question, I guess, to this is, what happens in the short term? Because, he is same thing. The husband was always looking after the finances to the point where she didn't even know passwords to online banking and that, because it never occurred to her that they would ever split. And then things turned very acrimonious. And then he literally just cut her and the kids off by being able to cancel bank cards and all those sorts of things. And in the short term, it was, how do you even buy groceries? And so I guess what you're really saying is make sure you do have a hand in knowing all of that. But unfortunately, sometimes it just doesn't cross your mind. Like, you just don't think of those things.
Absolutely, Carla. You are bang on there when it comes to that. So if people are thinking about separating with a partner, before taking that step, it's a really good idea just to pause for a moment and go and get some legal advice before you take that step. As a solicitor will be able to talk to you about these types of issues and give you some direction in terms of how to prepare for that so you're not left in that situation.
Yeah, right. Oh, sometimes it's hard. And that there are legal services, and we've spoken to them on this program. There are services out there that can provide assistance. It doesn't have to cost you an arm and a leg type of solicitor situation. You can get legal advice without having to pay an arm and a leg if you find yourself in that situation as well. Right, Hayley?
That is exactly right, Carla. Look, there are community-based services out there, generally in your local area, that can provide you with some free legal advice if need be.
Okay, all right. Here's another one actually that's just been sent through anonymously. I have a parenting plan with my ex, but he isn't following what we agreed for the kids. What can I do? Is there any way to make sure it's legally enforceable? A parenting plan?
Yes. So, Carla, a parenting plan is a document that parents can enter into to set out the agreed future care arrangements for their children. Now, while a parenting plan is recognised under the Family Law Act, it's not actually enforceable before a court if a parent fails to comply with their obligations in the plan. It's just another way that parents can document care arrangements for children, and is normally adopted where parents don't believe they'll need formal court orders and just a written agreement between them will be enough. But as we can see from this question, that's not always the case. So if a person has a parenting plan and the other parent is not complying with it, they should consider inviting that other parent to participate in family dispute resolution mediation. It's a bit of a mouthful, but it's with a registered practitioner to try and sort out the problem that they're having. Now, as part of that process, if any new agreement is reached or a variation is made to the existing agreement, the parties at that point can then agree to record that parenting arrangement for their children this time around in a binding court order. That means it will be enforceable in the future if a parent breaches the order by failing to comply with it.
Okay. All right. This one, Hayley, my guest right now, it's the Legal Lowdown. We do it every Wednesday at this time. Hayley Condon is the Family Law Special Counsel that joins us from Atwood Marshall Lawyers. We've got an email now from Brian from Tingalpa. He said, last year my wife and I divorced, but I never got around to updating my will. Is this something I need to do, or is it invalid anyway now that we are divorced?
This is a really good question, because divorce does have an impact on a will, but it does not of itself invalidate or revoke a will in its entirety. So I just want to clarify here that a divorce is different to a separation. It is the formal dissolution of a marriage. And divorce does impact a will as well as other estate planning documents that a person may have in place. So in Queensland, for example, a divorce will revoke those parts of a will that leave a gift to the former spouse and normally revokes the appointment of the former spouse in the role, for example, of an executor, trustee, or guardian. And it will revoke the appointment of the former spouse in an enduring power of attorney. However, the mere separation of a married couple does not have those impacts on a will or an enduring power of attorney. Now, Carla, when we think about it, as separated spouses must wait at least 12 months from the date of separation to apply for a divorce, and anything could happen to either party within that time frame.
Yeah.
Exactly right. It is best for people to review their estate planning documents after they separate and make the necessary changes to their documents at that point in time. And of course, not to forget the binding death benefit nomination for a super account or the nominated beneficiary on a life insurance policy. It's not just the will and the enduring power of attorney, Carla.
Yeah, right. There's so much to think of. And again, it's the things that happened in the short term before, if you go down the path of mediation or court or whatever. It's the things that you can do in the short term that are going to help protect you, that I guess when you're in the thick of it, and like we started at this, it's such an emotional time, you don't probably consider it all. You're just trying to get through the day-to-day as opposed to, your legal obligations and the things that you need to do in order for the relationship to be equitable once it finishes as well. There's so much. Before we wrap up, Hayley, I guess, what is one final takeaway that you would like to leave our afternoon's audience with about family law?
Every relationship, every family, and every case is different, and it's decided on its own facts. So the issues that may arise in one relationship may not exist in another, and the outcome in one case may be very different to another because of the different circumstances. So it is for this reason that it is recommended that a person who is on the verge of a separation or who has separated with their partner obtain legal advice in respect to their own circumstances. And this will allow you to formulate a plan on how you move forward and hopefully to achieve a cost-effective and prompt resolution to your situation, not only for you, but your children and extended family.
Family Law Special Counsel Hayley Condon from Atwood Marshall Lawyers. Thank you so much for joining us. Like Atwood Marshall joins us every week for the Legal Lowdown. We really appreciate your care and your consideration and your expertise above all.
Thank you, Carla. A pleasure.